All rise. The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you, everyone. Please be seated. We have a busy morning this morning with 3 cases set for oral arguments. We're going to have 2 oral arguments, and then the court will take a brief break, and then we will come right back and do the 3rd oral argument. I also want to acknowledge we're going to have some schools here today, and I don't mean to seem to make it too obvious, but I'm pretty sure they're sitting over there. Not that you guys look much older than students, but I figured it out. Okay, so I believe that we have Dallas Center Grimes with us today, and in particular, the Rho Kappa National Social Studies Honor Society. So welcome to our courtroom. And then we're going to have a different high school in the next hearing. So far, am I correct? It's only Dallas Center Grimes? Welcome. We're going to real quick tell you what high schools we graduated from. I graduated from Harlan High School in 1980, same day Mount St. Helens erupted. And then we'll go, a little interesting trivia for social studies. It was, look it up. To my seniority on a court, appellate court like this goes right to left, right to left, right to left. So that's how we're going to introduce ourselves. So I'll pass the baton.
So Tom Waterman from the Quad Cities, and I graduated from Bettendorf High School in 1977. That's right.
Ed Mansfield. I grew up in Lexington, Massachusetts, so not surprisingly, I graduated from Lexington High School.
Hi, I'm Christopher McDonald. I graduated from Des Moines Lincoln High School, and I do not believe there were any volcanic eruptions during that year, 1992, class of 92.
Hi, I'm Dana Oxley. I grew up in Greenfield, Iowa, so I graduated from what was then Greenfield High School. It's now Nottoway Valley in 1986.
I'm Matt McDermott. I grew up in Carroll, Iowa. I graduated from Kemper Catholic in 1996.
Hi, I'm David May. I grew up in Kirksville, Missouri, and I graduated from Kirksville High School in 1989.
I like to do that with high school kids. It's just to let you know, every career and profession starts pretty much somewhere, and with us, we certainly all went to high school too. So that's where it begins. So congratulations for your efforts. Our first case today is Venckus versus City of Iowa City and Andrew Rich, and it looks to me like the attorneys are ready. Mr. Diaz, you'll be arguing for the appellant, is that correct? And Ms. Craig for the city? Okay, thank you. Mr. Diaz, you may begin.
May it please the court, counsel. What high school did you go to? I graduated from Hicksville High School, Long Island, New York. Long Island, New York, 1976. Thank you, Your Honor. Good morning. Unlike last night's case, which was a false arrest case, this is a wrongful prosecution case. And again, different from last night, we had Chapter 669 involved, the state. Chapter 670 here is involved, and it does permit common law claims for what is described as malicious prosecution. The defense here argues that, that this claim cannot go forward as a malicious prosecution claim because there was initially probable cause to arrest Mr. Venckus. The problem with that is that if that were the case, that if in fact it had been a false arrest in the beginning, we would have a false arrest claim, which has only 2 elements, and we would not need to bring a malicious prosecution or wrongful prosecution claim, which has 6 elements, including an element of malice. So there is a distinction between these 2, and there has to be a distinction between these 2. There has to be the ability to bring a claim arising out of events that occur after probable cause may have been established, when you can establish that there is no probable cause.
Mr. Diaz, as I recall, the district court concluded that probable cause remained all the way throughout the case, up until the time the case was submitted to the jury, and the jury returned a not guilty verdict. In fact, the court denied 2 motions for judgment of acquittal. So given that, how do you end up with a malicious prosecution claim when there was always, if we assume there was always probable cause all the way through the case?
Part of it is what trial courts do, which sometimes they submit issues to juries. And part of it is that there is a development of facts that the court would not have been aware of at the time. So I think we had to look at the facts as we developed it in the course of this case, and that's been provided to the court in the briefing. And I think those facts are compelling. They establish far more than what would have been available and noticeable to a jury or noticeable to a trial judge.
Weren't all of the exculpatory facts ultimately presented to the jury, and the jury agreed with your client and acquitted him?
All of the exculpatory facts, well, many of them were submitted to the jury. The things that we didn't know is the extent of the knowledge of the detective as to what information had affected his opinions.
Yeah, but that goes to sort of a subjective test, and I thought probable cause is kind of an objective test. In a sense, it doesn't really matter what Detective Rich may have thought in his mind about the case if objectively there was probable cause for the case to go forward, right?
The probable cause that we've been able to establish shows that it's a question of when he got information and when he changed his opinion regarding what events took place, because he gave a deposition in April of 2016, 4 or 5 months before trial, that was different than what he testified to during the trial. And so he gained information during the course of that. And I think it's difficult for a trial judge necessarily to see all of those things as it lays out in the course of a trial versus what we were able to gather during the course of the discovery process. So I think that the analysis has to be based on the information that's been provided to this court on a malicious prosecution claim, rather than on that.
670 allows a malicious prosecution common law claim. Why do you need a God-free constitutional right to sue?
Argued that we're not allowed to assert that as a continuing prosecution claim. So if this court concludes that the probable cause standard that's set out in the malicious prosecution element trumps Mr. Venckus' claim because there was initially probable cause, which is what the defense argues, then the plaintiff at that point is left with no remedy and has to then look to the constitutional claim.
As a matter of Iowa common law, we will recognize a continuing tort of malicious prosecution where the probable cause goes away upon discovery of, I don't know, an airtight alibi or something like that. Then would you no longer need a God-free claim?
The claim could be provided. Whether we would need one, no. I think if the court says that we are allowed to proceed on our common law claim, that we would be satisfied with that. But I'm not going to speak for everybody else that might come along and say, no, we want to assert a constitutional claim. I think we were put in a spot where we asserted both, not knowing exactly what was going to transpire.
In this case, we have a claim against a detective, and once the prosecution starts, it's the county attorney's office that carries it forward. So, I mean, wasn't it out of his hands by that point? It wasn't his case. He's not the county attorney's client. He doesn't get to dictate whether it moves forward, does he?
Normal circumstances, that's a correct analysis under most situations, but that's not what the facts were here. He was acting like a prosecutor, right? He was going, for example, and I think that the evidence is probably most compelling is that there was the person who truly caused the rape of this woman was given a very good plea agreement, one which the prosecutor, the lead prosecutor, objected to at the time.
Into the other problem, or another problem that the city raises here, which is, as I read the earlier Venckus opinion, we left open the question whether the judicial process immunity could apply to the city and to the detective or not. Now, to the extent you're arguing now that, in effect, the detective ran the prosecution and was the decision maker, doesn't that then lead you directly into the judicial process immunity?
Judicial process immunity is, it depends on how broad you make that concept, right? Because ultimately, all malicious prosecution claims inherently have that feature to them, right? There's at some point that you have to have a prosecution in order to do that. So therefore, there is a section of time during which I think that the judicial process immunity doesn't apply. I think where it applies is if you're going to base your claim off of what occurs during the trial itself. Testimony, for example, is the best descriptor of the judicial process immunity. So I think the language, my recollection of the language in the original Venckus case was that we would apply judicial process immunity, but that we're not going to be trying to expand it, too far.
My understanding of malicious prosecution is sort of the kind of scenario where it might apply is where, let's say, a private party turns over information to the prosecutor, but they only give the prosecutor half the story or a third of the story, and they give a very selective or inaccurate version of the facts, and therefore the prosecutor isn't, playing with the full deck. But in this case, didn't the prosecutor have all the same information that Detective Rich had?
That's the beauty of this case, is that the prosecutor here, one, objected at the time to, first of all, we have to go back to April 1st when he gives his deposition. In that deposition, he takes the position that there was only one person who committed the rape, and that one person is Josh Venckus.
The prosecution sat in on that deposition. I mean, that's not information that the prosecution didn't have.
The prosecutor wasn't aware that he was going to change that testimony to that effect.
And I mean, that's not really a fact. I mean, people were trying to, it is sort of a situation where your client's DNA was found at different places in the victim's body, and it's something that is and was challenging for the defense to explain in that case, wasn't it?
I guess the point that I'm trying to make is that I think where we started from was that whether or not the prosecutor was aware of all of the information. I think the answer was no. I think that's evident from his testimony on April 1 and his testimony during the trial. They weren't aware that he was going to concede that Mr. Venckus was actually in Chicago at the time, or almost effectively all the time that would have been necessary for him not to have committed the crime. So I think there were so many factual features to this case that allows the continuing prosecution claim to go forward.
It was his opinion or his conclusion based on the actual, he had no firsthand knowledge. He was an investigator. That's his opinion or conclusion based on this state of the facts. But those same underlying facts were equally available to the prosecutor, weren't they?
That's the point. The prosecution was surprised that he got up there and finally conceded the fact that Mr. Venckus was in Chicago at the most important periods of time. And I think that's the feature to all of this case, is that I don't think the prosecution and the detective were on the same page. And particularly here,
Any evidence in the record from the prosecutor that Mr. Rich had the authority to shut down the prosecution, or that if the prosecutor would have known X, Y, or Z fact, would have terminated the prosecution?
I think the evidence is that he was involved in the decision-making with regard to offering the plea to the person who committed the rape.
Rich or the prosecutor? The prosecutor.
Rich was involved, right, in the course of that. He testified under oath that he wasn't involved. He said, I had nothing to do with the plea agreement, and the prosecutor then testified, not only was he in the room, but he was arguing in favor of offering a plea agreement to the person who actually committed the rape. So I think there's, and as part of that.
My question a little bit. So your contention is kind of Rich was driving the prosecution de facto. essentially.
Yes.
Evidence that would indicate that that's not true, or that was true, that the prosecutor actually said, if I would have known this from Rich, we wouldn't have prosecuted the case, or we would have terminated the prosecution, or even if we knew that, we still were going to go forward with the case. I'm kind of exploring this causation part of continuing the prosecution.
You know, my recollection is that I don't believe there's anything that specific. The closest we come is Detective Rich admitting that if he had gone to the prosecution with his doubts about the facts, which he then sort of testifies to during the course of the trial, that he would have been listened to. And the evidence then it's bootstrapped by the fact that he had in fact been involved in offering a plea agreement over the objection of the lead prosecutor.
You know, was driving at with Mr. Rich. I mean, excuse me, I recognize there was this April 1, 2016 deposition where he says, I believe there was only one person who committed a sex act with the victim, and that person was Venckus. And, but again, that's simply his conclusion based on evidence that he's gathered. If he went, if the prosecution went into trial and he testified to that, that wouldn't be enough to get to a jury. That's just an opinion offered by the investigator, right?
The lead investigator in the case, and he does this, and he does this just before the court then grants a severance of the cases, which then creates the problem for the prosecution. You've got a claim against Mr. Markley, who is the individual who was offered the plea agreement, and if you want to try the case against him, your lead investigator has just said he didn't do it. So how are you going to be able to prosecute him for the rape? So they were forced to then give him a pretty good plea agreement to which Rich was involved in.
To something you said earlier. You said if the common law malicious prosecution claim or continued prosecution claim doesn't lie here, then the constitutional tort would be kind of a substitute for an imperfect tort, essentially. Like if you couldn't make out the elements of continued prosecution, then you think you should be allowed a constitutional tort claim.
I think what I said was if you're not permitted to, if you cannot have a set of facts that allows you, after probable cause has been initially established, to establish that probable cause has now been lost, then I think that then somebody like Mr. Venckus would be without a remedy. Right. And so therefore, there.
The tort under common law, then we should get something different under the Constitution, but that gives him an opportunity for redress.
What I've said is that with regard to this case, our case, we would accept being able to go forward on the malicious prosecution claim itself. I think my time is up. And I don't know if and I apologize if I'm not catching on to what you want, but that's the way I look at it.
I think you understand kind of my view of Godfrey. So this is kind of what I wanted to explore. And I'm sympathetic to your position that plaintiffs should have an opportunity for redress. And I think where we disagree is I think there's a right way to get there, and I don't think it's Godfrey, and you think Godfrey is the more direct way. And I guess based on your answer, and we can do this in your next time, but it seems like what you're saying is this.
TSD there for just a sec.
Like, kind of your position is, with respect to these Godfrey claims, is if you can't make out a tort and you can't meet the elements of a tort, then we should just have some constitutional tort that approximates things that already exist at common law, just for an opportunity to redress. I mean, and that's kind of what you're saying here is if there are bars to continued prosecution, then he should get an Article 1, Section 1, Section 8, and Section 9 opportunity. Is that fair?
I think what I'm saying is in this particular case, I don't want to shut the door on that. And there's, look, I have issues with the malicious prosecution tort itself. For example, the requirement of malice, I think is, in many instances, an overwhelming element to sort of deal with. Not necessarily in this case, but it can be in that case. So I don't want to shut the door to the idea that you should have constitutional tort claims arise out of the Constitution itself. I'm just saying that what I want for Josh, who's gone through a terrifying experience, is I want him to have the opportunity to put forth his claim. I think that's really what I'm trying to drive at here. I'm not trying to grab for everything, but I'm saying we don't need everything if we have the malicious prosecution claim. But that doesn't mean that I won't, or somebody else won't be here someday arguing for, for that type of constitutional claim in this type of setting, if that makes sense. Thank you. Thank you, Your Honor.
Ms. Craig?
May it please the court, counsel. My name's Liz Craig. I'm here with co-counsel Jennifer Schwickerath, and we represent Detective Andrew Rich in the city of Iowa City. There are numerous grounds upon which you can affirm the district court's dismissal of this case, either on the merits or on the defenses. What the city sees as one of the most important aspects of this case is how Venckus's claim impacts the independence of the judicial process itself. Both his continued malicious prosecution claim and his constitutional claims go to the heart of the judicial process by seeking to impose liability on a police investigator for the actions of an independently motivated, independently informed, and independently minded criminal prosecutor. I'll address his malicious prosecution claim first. To clarify, and as you know, Venckus has never made a malicious prosecution claim as Iowa law has traditionally recognized it. From the beginning, and even when this case was in front of this court in Venckus 1, Venckus has conceded that Detective Rich had probable cause to charge him with sexual abuse. And to recap the facts supporting that probable cause, there was Venckus's DNA, including his sperm, on the victim's cervix, underwear, fingernails, a bite mark, and dress. There was the victim reporting 2 attacks separated in time. There was an eyewitness that reported seeing 2 different men at the house after the attack, one outside the house and one inside the house. There was a polygraph that one of his key alibi witnesses failed. And there was Venckus's disposal of his cell phone the day after the assault occurred. Given the existence of probable cause, there was no wrongful instigation of this prosecution by Rich, and no want of probable cause upon Rich filing his complaint against Venckus. Venckus nonetheless claims that Detective Rich should be held liable for the ensuing criminal prosecution. First, there's the issue of timing. When must a lack of probable cause be shown, and when must malice be shown? The city's position is that these essential elements of a malicious prosecution claim must exist at the instigation of the prosecution, not after the prosecution is already underway.
There's that restatement provision that you say we've never adopted. Let's say we adopt it, because usually we like the restatement of torts and we find it pretty persuasive. So let's assume we adopt that. Why does this sort of continuing malicious prosecution tort not succeed here?
As you say, it hasn't been adopted. I do see numerous problems with the restatement's provision in terms of how it impacts the judicial process immunity. Regarding the merits of this case, the probable cause that existed upon Rich's charge never dissipated. The district court found that there wasn't a genuine issue of material fact about whether or not Rich ever believed probable cause dissipated. Rich believed throughout the prosecution until the end that Venckus was guilty. And more importantly, Ann Leahy, the prosecutor who had tried hundreds of cases and over 50 sexual assault cases during her 30-year career at the Johnson County Attorney's Office, she believed that Venckus was guilty. And it wasn't just his DNA that made her think that. It was all of the evidence supporting probable cause that I just recapped. None of the forensic evidence that existed at the beginning of this case was ever conclusively rebutted. Rich's Rich was presented with that evidence, and he had no reason to doubt it other than Venckus's retained expert, who put forth a defense that there was transfer from Venckus's personal blanket, which had traveled from the basement apartment up into the main part of this house in the middle of February night.
Separate structure other than Venckus? Because that blanket came over from the structure to the living room where the victim was raped, right? And so my question is, who else lived over in that separate structure besides him?
My understanding is that there was one other individual, Colton Oberbroekling, who lived there. Venckus and Oberbroekling lived there. Oberbroekling was acknowledged to be at the party on that night. And Venckus was said not to be at the party that night. It was his friends that he lived with in that home, and they all said he wasn't there. But that was his personal blanket, and it was a very personal blanket. And it traveled a long way to get to the scene of this crime, to then have his DNA transferred, not just to one place on the victim, but to many places on the victim.
The counsel's argument that if the common law claim fails, that there should be a constitutional substitute that would recognize this continued malicious prosecution claim.
Constitution should be used for a substitute for failed common law claims. I don't believe that's what the Constitution is supposed to do. It protects Iowans' rights. It's meant to be used offensively to protect all of our rights on many levels, on a different, for all of our different rights. But I don't believe that it's the opportunity to make new law for failed common law claims. We have a long history of many common law claims that potentially fit situations and provide remedies. And it's not the Constitution that should provide a new source of.
That isn't at all what anything in Godfrey said. I mean, what Godfrey said was the Constitution's the highest law of the state, and therefore, when that highest law of the state is violated, people ought to have a remedy. And then from there, Chief Justice Cady, in his special concurrence, said, but if there's already an adequate remedy, and in this case, he was referring to the Iowa Civil Rights Act as an adequate remedy for a claim of discrimination based on sexual orientation. If that's already there, then you don't necessarily have a Godfrey claim. It wasn't the idea that we would just invent constitutional claims because there is no common law remedy. It's completely the other way around we were discussing in Godfrey, right?
Your characterization of that, Justice Mansfield, but I don't think that's the way it's been argued out in this case. I think the way it's just today been argued out is, I may not have a malicious prosecution claim under Iowa common law because probable cause undisputably existed at the beginning of this prosecution. But I might have a claim under the Iowa Constitution. I think it falls under substantive due process. It may fall under search and seizure clause. It may fall under the inalienable rights clause.
And if you'll recall, when we heard the original Venckus case, I think I was questioning Mr. Diaz about how does he get from Article 1, Section 8 or Article 1, Section 9 to the specific causes of action or claims he's asserting in this case. I agree that isn't the appropriate process to take a common law claim and then shoehorn it into the Constitution. I agree with you on that.
What you're being asked to do today.
A different fact pattern, and there was evidence after the fact developed in this case that Mr. Rich had a subjective belief that Venckus was innocent, and he, at some point during the investigation, he believed that, but nonetheless advised the prosecutor to continue forward. Maybe it's a personal grudge, whatever the hypothetical is. Is that a due process violation? Is that a constitutional tort?
I guess I don't know. Iowa law, I don't think it would be, as long as the prosecutor had the information to make her own independent evaluation of these facts.
A continuing malicious prosecution claim?
No, I don't think so, not even under the restatement. it would have been required that Rich did something even more than believing Venckus was innocent.
Maybe he had information about an airtight alibi, so he had that fact, but he didn't give it to the prosecutor. Then would it be, but he just withheld that actual evidence, so then the prosecutor didn't have all the evidence. Could that be a malicious prosecution claim?
Iowa law as it exists. And I don't even think under the restatement that exists, because not only should the witness know that probable cause has dissipated, which I think is the situation that you're describing, but then the witness has to actually push forward in an affirmative way. And in the restatement, if you look at the comments, it describes a situation that's almost akin to extortion. It's trying to turn this prosecution into something for the witness to benefit from in some way and push some ulterior motive. So I don't think the situation that you're describing, which is essentially what we're facing here today, is Venckus saying, Rich couldn't have believed I'm guilty. At some point in time between April 1st and the end of trial, he didn't think I was guilty anymore. But there is nothing in the record to point to say that even if Rich did believe that, which he did not, that he did anything to push forward this prosecution. That the prosecutor was independently motivated. And even in the Venckus 1 case, the claim against the prosecutors that was allowed to go forward was this allegation that they were so independently motivated that they actually interfered with the prosecution by making an ethics complaint against his defense attorney. So apparently these prosecutors were extremely motivated to find Venckus guilty on their own without Rich.
Prosecutor that has bad motive. Is that a constitutional tort? And is it a malicious prosecution tort?
I don't think that's a tort that we can recognize and maintain the integrity of the judicial process for all the reasons that are discussed in Venckus 1 and in Minor. The questioning into the prosecutor's motives, if we start going down that path, we're going to start interfering with the independence of prosecutors, which then, of course, in turn interferes with the truth-finding process of the judicial process itself.
Here, though, where the plaintiff argues that the detective was given sort of a prosecution-type authority to make calls in this case, does that matter?
I don't think there's any evidence to support that. For one thing, if you look at Exhibit E,
Is.
assuming that there is, I think that falls squarely within judicial process immunity under Minor. We're looking at a functional analysis. And a functional analysis of judicial process immunity is so key because it goes to maintaining the integrity of the process. Of course, as you know, judicial process immunity is not meant to protect individuals. It's meant to protect the process itself. And so if he indeed was acting as a prosecutor, which there's no facts to support, then the judicial process immunity would kick in. And the timeline of events, we're in the last 5.5 months of an almost 2-year prosecution when Mr. Venckus's complaints against Detective Rich apparently kick in. If that is not in the midst of or towards the very end of judicial process, I don't know what is. This prosecution went on for 2 years. It was heavily litigated, fiercely litigated with motions, lengthy motions about the admissibility of the DNA evidence, about whether DCI's processes were reliable, about whether there was probable cause. Closing in within months of trial, there was a motion by the defense saying, for a motion for bill of particulars, asking the state to say what the basis of their charges were. And they said, well, it's the DNA. You've known this all along. And it was summarily denied by the district court. There were 2 motions for directed verdict during the trial. Both were denied. The idea that probable cause dissipated is just, it's unsupported by anything in the record, in the criminal trial or in the civil case.
From Godfrey, but it's been on the books since 2017, and we have all the values of stare decisis in promoting the predictability and stability of our law and not lightly overruling our precedent. In view of all the immunity defenses, is it still causing problems that warrant overruling that precedent?
This court has an obligation to overrule precedent if it is inconsistent with the Iowa Constitution. And I do believe that Godfrey is inconsistent in that the separation of powers is impacted by that decision. You're asked to make law, and this is a perfect example of why Godfrey is problematic. Here we are with a litigant saying, well, I don't have an adequate remedy under the Iowa law. But look under the Iowa Constitution. I think there could be a substantive due process claim there. Let's formulate one judicially that fits my cause of action.
Again, that's not really the way it should work. I think what you argued in your brief, and I think you're very capable of arguing that, is there's no substantive due process violation because there's no outrageous conduct. What's wrong with applying that well-established constitutional standard to the facts of this case? You do it in your brief, and the district court did it below. Is that hard?
I don't think it's that hard in this case. No, I don't think it's hard if you reach the merits of this case. But there is the bigger issue of Godfrey out there, and we do argue in our brief that this court should overturn Godfrey. And I think the fact that these cases have to be litigated. I mean, I didn't just show up here today to argue this case. This case has been going on since 2018 now.
Kind of the issue with it is it's not whether there's constitutional law existing. It's we have to decide now, case by case, action by action, whether this is a monetary tort, whether it's substantive due process, inalienable rights, cruel and unusual punishment, and then each particular fact pattern has to be litigated because now we have Harlow immunity, all due care immunity. I mean, so your point is well taken. Yes, under existing constitutional law, there's no violation. But that doesn't necessarily answer the argument here, which is there should be a substitute tort. I mean, isn't that your point?
Yes, it is. And I think that it gets at the bigger issue with Godfrey, which is it's generating claims and putting this court and district courts across the state of Iowa in the position of having to make calls about what Iowa law is and having to create remedies on a case-by-case basis. And I don't think that's the function of this court under our system of Iowa government, under the Iowa Constitution. That the separation of powers that this court upholds, it doesn't permit the court to be making a remedy under any situation that is brought to its doorstep as a constitutional claim.
You may wrap up.
In suing Detective Rich, a police investigator, for a rightfully commenced criminal prosecution carried on by independent prosecutors, Venckus imperils the integrity and independence of the judicial process. The district court correctly dismissed his claims on summary judgment, and Detective Rich and the city ask that this court affirm. Thank you.
Mr. Diaz. Thank you, Your Honor. This is the time that Justice McDonald's referring to.
Thank you, Your Honor. So let's see.
In advertising, can we pick up where we left off on the scope of the Godfrey claim? And so kind of two questions regarding the scope, which is the first one, is there any category of government official that is exempt from Godfrey claims? So far we've had the governor, the lieutenant governor, the chief of staff, the chief legal officer. I believe you personally have represented litigants involving cases with social workers, detectives, officers, prosecutors, counties, states, or the state. So is there a government official or state employee that would be exempt from these kinds of claims?
Well, I think we've exempted prosecutors. I think that we have absolute immunity with regard to prosecutors, and I think we've exempted judges. But my recollection is that those common law immunities are applicable to constitutional tort claims. That's what my recollection of the opinions. So I think, yeah, I certainly think that we have scenarios in which there are policy decisions that we make with regard to it. But as a general proposition, I mean, what is the Iowa Constitution if it's not protective of everyone, and it's not demanding of every citizen? So if you're a government official, you're expected to follow the Constitution. You take, in many instances, you swear an oath to do exactly to that. So I don't think we're,
Official. So let's take a public defender who, in a case, a criminal case, there's a finding of ineffective assistance of counsel under the state constitution, which is an Article 1, Section 10 violation. Is that person then subject to some sort of civil suit from his client for violating his constitutional right to the effective assistance of counsel?
that's answered by Godfrey, and Justice Cady's concurrence in Godfrey that says, basically, is there an adequate remedy at law available to that individual? And obviously, there's Chapter 669, if it's a public defender, it would be a state employee, and you could bring a Chapter 669 claim arising out of negligence or professional negligence. So I think that, you know, where I'm focused, and there's been some pushback on this, and the concern I have is, here's a gentleman who was expelled because of the allegations and because of the prosecution. He was expelled from the University of Iowa. He lost an internship with the Big Ten Network. He was unable to find adequate employment consistent with his skill level. He had to spend or incur more than $100,000 in defending himself in this case, and he was innocent.
I mean, you teed it up really well, and Ms. Craig did as well. That line of facts, I'm a former prosecutor, and I'm thinking, dang, I got DNA. You're going to get the train down the track, at least starting. But the things that she talked about, and that the complaints weren't made till the very end of the prosecution, I mean, yeah, there was one heck of a great defense. But that's what happens when the case goes to trial, and you got an acquittal. I don't know if it was you, I apologize, but he got an acquittal. Okay, you got an acquittal. So the process seems to have worked. Help me understand that.
And that's why I think and I agree with you that the train gets started, okay? And all of the facts that she laid out at the beginning were all of the facts at the beginning of the case. But the requirement of the law.
On that, she said those things were never rebutted.
Oh, I disagree. Oh, I disagree completely. There's a whole section, and we talk about the DNA. The DNA were fragments of his DNA that came from the blanket. There was
DNA at the scene. That you could not rebut, correct?
DNA at my home. I mean, just because it's found in his residence, right, or in this case on this person who has a blanket that belongs to him covered, and we know why that occurred. And it occurred. And remember, his DNA shows up on sperm without any seminal fluid. It shows up on sperm without any epithelial skin cells.
Experts, and these are the kinds of arguments that were made at trial. But it might be a different story if you had that your expert was completely unrebutted. But what do you do with the fact that the state had an expert that rebutted this transfer theory?
DNA. I mean, the DNA, you know, I was answering a question specific to DNA. The facts were he was in Chicago. He was in Chicago, according to even Detective Rich's own testimony, he was in Chicago up until 1 o'clock in the morning.
And that's a great defense, and it worked. So I'm struggling with there are a lot of people out there in the country who have been either wrongfully charged or there was not a conviction, they got an acquittal. And I'm sure there was some fallout in their life, whether it be a marriage, a job, a potential job, whatever it might be. Wouldn't we have that happening all the time at every acquittal down the road?
Well, I think we have a problem with wrongful prosecutions. We know that. We know that from we watch it on television all the time. That's a separate question from whether or not an individual can prove from that there was something about the prosecution that was wrongful. And just because you go through the process and get acquitted doesn't necessarily mean that you've got the ability to assert a malicious prosecution claim. That all depends on the facts and circumstances of the case. In this case, where the gentleman is 240 miles away at the time, is no way that he could physically be in Iowa City. The fact that you have some DNA in his residence on a blanket that ends up getting transferred onto the victim, that is the kind of information that is the sort of the icing on the cake as to why you can say there's no way that this man did what he's alleged to have done. And you begin with the fact that there's a concession during the trial. They knew that he was there till 1 o'clock, but they had been saying, no, no, no. He never left Iowa City the entire time throughout the entire prosecution. The comment of integrity of the judicial process has been thrown out here by the defense, and I find it interesting that ultimately the integrity of the judicial process is at stake when we attempt to convict people who didn't do the crime. Thank you, Your Honor.
The City of Iowa City, and Andrew Rich is hereby submitted. And we will have a changing of the guard. Different attorneys will be for the next case. And it's my understanding perhaps maybe the next school is here as well. So we'll stay on the bench, but we'll have a transition here.